Okay, it's my great pleasure to introduce three more friends. This is wonderful. It's like, really, you just have a conference so you can invite all your friends and you can see them. The bad part is you can't get to all their sessions because, you know, everybody's presenting at the same time. There's so many wonderful people that you don't get to go to all of it, and that's my only regret about this. So I want to introduce to you now three women who I have known for a long time in different capacities. I'll start with Lisa because she's the closest to me geographically in this room. And I first met Lisa when she was 12 years old. And do you want me to tell them how old you are now? How old are you now? 42. Yeah. So we've known each other a long time. What she calls the dry-bry fruiting, and those of you who work for corrections who can only just imagine this, and those of you who don't can also imagine it. I'm walking into the Young Offender Center, as it's known. I want to put sick beside it because those of you know I hate that term because offender does not define someone. But that's what it was called, the Calgary Young Offender Center. Or actually, it was the Bow River Young Offender Center at the time. And I walked in, and some boys had been hassling Lisa. Lisa was one of the few young women in there, and they were hassling her, and she decided to pitch an apple at one of them. Her aim was not so great, and it came flying through the air and hit the warden in the head as I'm walking, and I'm trying to look around and think, I wonder where that came from. As she's laughing, and everybody's laughing, and needless to say, it was not the best way for us to meet, but it meant we met right away in an advocacy situation. So, those of you who know Lisa probably most unfortunately know her because, I say unfortunately only because it's the unfortunate circumstance that Lisa became known fairly well nationally. She was labeled the second dangerous offender, a woman, as a dangerous, again, offender in 1994 at the age of 21 in what the Alberta Court of Appeal later called being labeled dangerous for what she said and what she wrote, not for what she did. And so, not a big surprise, it was eventually overturned. But sadly, it took 6.5 years for that to happen. And she spent most of that time in isolation and a significant part of it in this province, both at the Regional Psychiatric Centre and most of it in the segregated maximum security unit that existed at Saskatchewan Penitentiary for a period for almost 8 years. And then she spent the last 6 months at the Healing Lodge, and then was basically faced the rest of her life in prison, and then within one day of the decision, knew that she would be being released, and 3 days later, so June 29th, 1999, the Alberta Court of Appeal ruled that she should overturn the designation and determined that she should be released immediately, and it took them until July 1st to release her. Yvonne Johnson, I first met in 1992 when I started in the job as the National Director of Sallows Fry. I certainly knew of her before then because I had been working in Calgary, predominantly with men and young people, as her trial unfolded, and she was tried and convicted in Wetaskiwin in what we came to be able to describe for the purposes of her 15-year review as a racist community that would not give her a fair trial, and on that basis we're able to get a change of venue, but unfortunately weren't involved in the beginning part of her time, and she was convicted, first Aboriginal woman convicted of first-degree murder in this country and sentenced to life with no parole eligibility for 25 years. And then went on to resist that and work with the Sisterhood in the Prison for Women and welcome neophytes like me as I was starting in, and helped, like Lisa, to educate me about many of the issues at the Prison for Women. And many of you will know her as the co-author with Rudy Wiebe of Stolen Life, Journey of a Cree Woman. And that started a whole nother journey that led to very great challenges in helping in Yvonne being able to advocate and help release herself from the prison system. And we'll maybe talk a bit about that in this but more in the next session. And then last but certainly not least is Sheila Wildeman, who's a professor at the law school. I still have trouble. I hiccup over Schulich School of Law, but okay, there I said it. But it was Dalhousie Law School, which I hiccup over partly because many years ago, more than 32, it's where I graduated from, and in what Lisa described as, my my beginning of my not figuring out how to practice things, so I never did it. So I thought it was an interesting challenge about why I don't do real law, but Lisa was also the person who coined the term recovering lawyer for me, which I thought was very kind. Yeah. So, but Sheila, I first had the privilege of meeting when she was a student, and she was doing some incredible research that still stands the test of time, in my view. And she was looking at the... Sheila just said that's because nothing changes. Well, that's also true, but it's also true that what you did was the first time I had seen a law student in particular, but a lawyer even, really take on the challenge of identifying why the arguments for more mental health services in a prison were problematic. And I think we all know that's true now, but I'm not sure everybody knew it was true at the time. And I think that groundbreaking work really did open the way for many to develop their thinking, including me, in that area. And so I thank you for that. And you've gone on to do lots of other incredible things, and I had the privilege of having a little bit of time to work with you last year when I was at Dal to do the intensive prison law course. So, and a great panel, like so many of the other great panels, but and then again different in different ways. And one of the things we talked about was really posing some questions to each of these three amazing women about the work they've done. But first, I'd like to open it up and give you each a few minutes to say whatever you'd like to say about the subject area. And the subject, as you can see from the agenda, is prisons. Lots of rules, not much rule of law, which, thanks to Sheila, was a really good description, really picking up on something that Louise Arbour said about the prison for women, there being an abundance of law and policy, but no real evidence of, and no evidence that the system could embed the rule of law within itself. And so, you go, okay. Thank you for letting me know. So that must mean you want me to start with Sheila then, on the other side? Okay. Sure.
Is this working? Yes? I actually just want to preface what I have to say. I have a little bit to say about the rule of law and a little bit to say about what I think the opposite of that is, which is a state of war. But I'm going to save that for a second. Like others, I want to start by acknowledging that we're on the traditional territories of the Cree and Métis Nation. And I want to preface my answer with, my various answers, with a couple of other things. First, just to say that I'm incredibly humbled, and I was actually just really kind of terrified because it's so thrilling to be on a panel with these two women, and of course with Kim as well, just because of their heroism, really, their lived experience and their articulation of that experience in such really, I can't think of another word, but heroic ways. So that is incredibly humbling. And so I want to say I'm not the expert on this panel on law and the rule of law or the rule of rules in prisons. I'm actually the foil for Lisa and Yvonne's expertise and wisdom because they know the law from inside the prison, where the law and the rule of law is put to the test and proven for what it is or what it isn't. And my second prefatory remark, again, avoiding the bigger questions, is thank you to Kim. And I know we all want to say that, and some of us have got a chance, but I want to work in my chance to say thanks to Kim Pate for all your goddamn endless questions. Your questions here and to us, but especially inside the closed culture of prisons. And thanks for bringing us together here in Saskatoon, as we're all, clapping for, bridging our different worlds and making us think about how they connect. So, and my last prefatory remark, I guess, is as I just wanted to say, as I prepared for this panel, on my sort of my great aspirations. Wow, I get to be on this panel. I had to think really hard about my privilege. So my privileged white settler body and the life experiences that have come with it, and how these things distance me from my co-panelists who I so deeply respect. And so, I had to think about that, but I also had to think about what you might call my spirit. So not just my white settler body, but my aspirations, which strain to stand. And I'm totally emotionally labile. So when I get all teary, it could be for no reason at all. but my aspirations, which strain to stand in solidarity with Lisa and Yvonne, and to activate my responsibility to them and to others inside prisons now, which I want to suggest, I'll come back to my theme, are better described not by the concept of the rule of law, but by that of a state of war. Okay, that's my opener. Over to you.
Yvonne?
Oh, I was just starting to relax.
Oh, sorry. No, you're on. You have to work on this panel.
Test. No. Can you hear? Because I can go loud, but I usually talk very quiet. One of the first things that I'd like to acknowledge is the long trip. Like, I've lost too many women. Women that I knew through conflicts of the law, incarceration, parole, that are no longer with us. I was incarcerated in 89. I was day paroled in 2008, almost 20 years consecutively. And in those years, I've seen many that are no longer with us. And I've had elders tell me, if you treat a human being good while they're alive, there's no reason for tears when they die. But I really miss those women, because how alone they was, I believe, at the time of death. I was speaking about women that I've known that did not survive the pig farm in BC. Women that I've known that didn't survive being found in killing fields all the way across Canada. Edmonton has them, Saskatoon has it, Regina has it. It's dumping fields. I've been paying attention to that for the 20 years that I was in prison, and since then, that way back in 89, they were saying that there was somebody or someone killing sex trade workers, and the majority of them at that time was Native women that were being found dead, who were known to be in the sex trades. And there was bodies found that they obviously did not do any form of proper investigation on behalf of this human being who they found that was in the stages of just skeletal remains. That within not even 5 feet from where they found her remains, later they found the same remains of a woman who was actually deceased longer than this woman was. And then the police kind of say, oh, we don't have a serial killer. They've had serial killers out for Native people since this time, since this country has been preoccupied by non-Native people. We're an expendable race of beings here in Canada, that the very justice system, the very government itself, through their treatment in dealing with us, that has formulated everything that exists now. I truly believe that. From the Native people, from the genocide, from the term colonialism, we were all set up as an expendable race of people. They say, oh, well, it's just because all natives are bad and they're all drunks and they're all this and that. No, You go from complete absolute genocide to law traitorism, to be made treaties that were broken, that became useless pieces of paper after they were signed, even before they imprisoned us. Reserves are land set aside, same as every federal prison in Canada. Land set aside for the incarceration and the confines of a people. They had made prisons of grass that they call reserves. Every prison in Canada is called reserves before they're called prisons or federal prisons. So the Native people have been lied to, manipulated, genocide, put onto reserves, their children stolen, their identity stolen. And I was thinking about that. We had our drums, our ceremonies, everything outlawed from within the prison of a reserve. A Native person could not leave a reserve in Canada without an ETA, a UTA, a work release, until we legally had the right to vote, which was in the 60s, which would make me 10 years old, when the Canadian government finally acknowledged that the Native people in Canada, oh, we're gonna let them be Canadians now. We're gonna let them out of their prisons. So they built the residential school, the governments, the policies, the Indian affairs, and they needed human beings to do this. And who is the most expendable in Canada? The promotion of hatred, set-asidement. People who say, I am not racist, don't even know that they're racist. They don't, because they're given that right or that teaching or that building of the universe and the safety of that around them. That I believe in history at this day and age, that the white people, like I've always asked, we know where the Native people came from. We know where the black people came from. We know where the yellow race came from. But nobody has been able to tell me exactly where it was that the white nation came from, besides all the other countries the world over saying they came in, they came in, they came in. And it was like a walk right over the whole world in the universe until they says, oh, we've discovered some land. How can you discover something that was never lost to the people who lived on it? How can you claim something that is already preoccupied by beings on there? They come in, they didn't even have the audacity to wage war on us. They were just that deceiving and lying, and the Native people were that trusting, that innocent, and that beautiful. They didn't have a concept of this big, awful thing that was actually coming. Part of the treaty was, when they first come, they says, you're not to live above us, below us. You are to live parallel alongside of us. And the Native people thought they were going to come and live just as they were. You know, where they didn't war or imprison or even like, they didn't need governments. They had creators law, which said love, kindness, humanity. The people that came didn't have those teachings. It was kill, lust, want, lie, conquer, war. They didn't even have the audacity to wage war on us. They just lied, manipulated, genocide. So they went through all these stages of founding the Canadian government that we have now on the expense of the Native people. Unlike any other country. That's why I rage when you hear about Brazil, them going in there and doing that. And I says, you big dummies, you haven't learned anything over here?
Okay, I'm going to stop you there and go to, and then we're going to come back to those questions. So
Yeah.
Thanks, Yvonne.
Thank you.
Anything you want to say at the beginning, or we can move to the question?
Okay, I think that if I one thing that really picks my butt is the fact that there's a few things that really bother me, but my main focus will always be the Dangerous Offenders Act because it's what affected me the most. As I was kind of saying, when I was 21, I was the only woman in Canada to ever get an internment sentence. Marlene Moore was the first in 1988, but she got 2 years less a day. She got a determinate sentence, and I was after her, and I got the internment sentence at the age of 21. So my whole feeling about this is that you should send someone to jail for what they do, not for a hypothetical situation. How can you give somebody a life sentence and say, you know, the judge tells you your sentence expiry is your natural term of death? How do you justify sending someone to jail on a hypothetical situation? I think it's ridiculous, I think it's inappropriate, and I hope we all fight it. That's all I
Great.
say.
Okay. Thanks, Lisa.
Now I just feel real cheap.
We should share that Yvonne is an incredible storyteller, and she invited me to, she said the nice way I do it, I'm not sure it's always the nicest way, but to move her along. So I will, in the nicest way that I can, move you along from time to time. Not because I don't want to hear her, because.
Okay, say one more thing?
Yeah.
Okay, just thinking, and I would like to discuss the use of restraints in prison. This is become a very popular thing for the women to be put in restraints, and I think I would like to speak with that. The slashings, negative things happen, and I think that has to be addressed. That restraints should not be used against anyone in any situation. I don't find it justifiable, no matter what the behavior is. You do not deserve to be strapped to a chair, strapped to a bed, have your clothes taken off, and be injected with drugs. I think it's totally crazy.
So I'm just going to urge you guys to move the mic towards each other when you're talking. So the questions that we talked about in addressing here, picking up on what each of you have said, is, is the rule of law pure crap? Is it, is there anything to be salvaged in saying about the rule of law? And when we're talking about it, what does it mean when you're actually in a prison, the rule of law? Lisa, you've raised the whole issue of whether in fact, the use of restraints, there are rules around that.
Yeah, but when I was
Yvonne-
in jail, there was, okay,
Yeah,
sorry.
hang on a minute.
Okay.
Yvonne, you raised the issue of whether even the rule of law should be respected implicitly by the way you've introduced these issues. And Sheila, you actually posed this question, which I thought was a great one. So you actually said, is it pure bullshit? But I thought,
Well, I was
Seeing as
using Yvonne's words from
That's
last
right.
night, I think, when we talked about the topic of the panel, so I thought, yeah.
so who would like to go first?
What is the question?
Is the rule of law pure crap in and around?
That's the
prison?
nicest thing I ever heard you say, Kim.
For me?
Crap is the nicest word I ever heard you say. So, what do I think about that?
Mike.
Oh,
Yeah.
sorry. Hello. I think that the rule of thumb in prison and rules should be consistent across Canada. There should be one set of rules saying like A, B, C, D, and they should be followed. And I think that the staff do not have the right to improvise segregation tools. I don't think they have the right to improvise things to keep you restrained. I think they have the right to give you injections or, we'll give you a cigarette if you do this,
So essentially what you're answering is, even though the law is the same all across the
Yes,
country,
there's
it's
differences.
experienced very differently depending on who's in charge.
Yeah. And I think that, I just think that it's an issue that everything has to be done to help the women. Forget about protocol, forget about, how can you stand there when someone's strapped to a bed and not feel anything, no compassion? What kind of person does that? I mean, if they did that to somebody on the street, they'd be charged in lawful confinement, you know what I'm saying? What gives you the right in prison to have someone strapped to bed or be in a straitjacket with a helmet? And then if we were to do that to them, what would happen to us? It's just ridiculous. I'm done.
When she speaks about the chairs in the lockdown, I remember back in P4W, they still had the practice that they called the four-pointer, the star. That's where they come in, they strip you, they take the mattress off your bed, you were left on the springs of that bed, and your ankles were tied to the corner of the tables, the end of the bed and up on the top, and you were left there. And you were left there to wherever or whenever they decided to come and let you loose. I've seen it to where they said it was more humane. People that always say, Yvonne, you got away with them, you can calm them down.
Yes,
There was one girl in P4W, she was in a situation like her, she was dumped, she was in prison, she was locked up, she was segregated. Her first name was Sandy, I won't share her last name. Their total idea was to lock them up, throw them away, and pay no attention. Peer support would get a hold of me and they'd say, Yvonne, she's the only one that you would listen to. And this one was categorized as the institutional dangerous offender of P4 or whatever at the time. But I could walk into segregation, I could grab a chair, I can sit it next to her seg bars, I can talk to her, and give or take a half hour, she was sleeping. She'd fall asleep on me. I'd get up, I'd quietly leave, and I'd go. Other ones, Tammy, RPC, they'd lock her up, throw her in her cell. She'd be in there just going crazy, yelling, hollering, and everything. I'd grab my hand drum, I'd go over, I'd sit by her cell, I'd have the hand drum, I'd start singing. It's as much as a choice of compassion while you're inside. When all those Native women got killed through self-suicide, Harry Carey and P4W, we fought way back in '92 to take Corrections Canada outside court to have them look at why all these women were committed suicide and what the suffering on the inside and the rioting and what caused the violence. So they brought in a few things, phone calls, PFVs and that, but then some of the women were still committed suicide. It was almost like one a month there for a year. The last one, they thought because there was a stir-up happening around there, we believe the last one, they says, oh no, we don't need another dead Indian. But yet they let her hang long enough for her to be brain dead before they could cut her down. Then they put her into the outside hospital on life support. And she was officially dead. And they didn't take that life support off of her till the prisons were closed, the other ones were built, and they were already operative. Then they took it off. There wasn't nothing left of her. And then when they were questioned, why did you not administer first aid or cut her down or do something like that? They said, not in my job description, and that is what they said. It is not in my job description. So when they started opening up the new facilities, we fought and fought for them to make it mandatory in their training when they went to be staffed to work in that prison that they had to have first aid, CPR, so they were under direct that if they were found slashing, hanging, self-mutilating, that they were to intercede and help that human being in their suffering rather than saying, oh, it's not my job description.
And they're going to say.
So then, yeah, and then they're told to do that. So it does fall down to their choice. And then the media sitting here saying, oh, there is some good guys in there. I could understand her rage at the media. Was where in humanity is it justifiable under law or the pretense of law or the guise or even the hidden intention of law that a human being can choose a $35 an hour job over a human life? And that's what it cracked up to be.
Good job, Mom.
It's the law. It's the absence of law, the illusion of it.
Okay, and Sheila?
All right. So I wrote stuff up because that's what I do. I wrote stuff up. But I want to go back to, and I guess, Bridge, from what you guys are saying, go back to former Justice Louise Arbour's report in the mid-'90s, right, that she produced out of what she called certain incidents occurring at the prison for women, where she said, as Kim already said, the rule of law is absent, although rules are everywhere. And in the same report, Justice Arbour said there was little hope that the rule of law will implant itself within the correctional culture, I'm quoting her, without assistance and control from Parliament and the courts. So assistance and control from Parliament and the courts. So I guess the question is, for this panel, if we're talking about the rule of law in prisons, how's that working out? How's everybody feeling about that? That hope, that little hope for the rule of law in correctional culture. So first, I just want to say something just briefly about what we're talking about when we use this highly charged, contested term, the rule of law, which is actually just a platform for fighting about how we should order our society, pretty much. But there are some generally accepted meanings of the rule of law within judicial discourse. So within our, tradition of in Canada, Canadian courts, case law. So first, principle number 1 under the rule of law, they say, well, government must act in accordance with law and not what appears to be the opposite of that, arbitrarily. So government, state-backed officials must act in accordance with law, and state-backed decisions must find their source in law. So this is the idea. And in addition, courts attach to the rule of law the expectation of independent adjudication of individual rights, so that you can get out of whatever box you're in and have an independent adjudicator assess the justification or lack of justification of that. Now this bit about access to independent adjudication of individual rights, that includes some opportunity to access the courts. But despite a pretty good decision from last year from the Supreme Court of Canada that moved us about a centimeter further on state duties not to impede access to the courts, they're in the form of hearing fees, it's BC trial lawyers' decision, it still remains the case that no one, and in particular no prisoners get free legal counsel for all matters, and in particular for prison disciplinary matters. So that's a pretty big deal about the rule of law and whether or not it's there in prisons. And those are just the basic, or what you can call minimal, rule of law values. The state has to act in accordance with law, not arbitrarily. You got to have some access to independent adjudication. But I, actually, and others from whom I've learned, adopt a more thick or substantive understanding of the rule of law, of what we're talking about when we talk about the rule of law. And it builds in respect for agency, for human agency, and human rights. It builds that into what we're talking about when we talk about the rule of law. So it's an idea that on this thicker version, it expresses an expectation that states and state-backed authorities, we're talking correctional officials, we're talking about anybody exercising the power of law, will be responsive to those affected by law through the mechanism of law, right? So rather than just using law to exercise power, right, top-down authority like using the rules in prisons, this idea of the rule of law says that law is a kind of an opening of a space in which those exercising legal authority are compelled to take account of the significant interests of those affected by their decisions and invite their participation, right, into that forum. So there's participatory rights and there's substantive legality, taking account of those fundamental interests built into this idea of the rule of law. So I'm taking a bit of time to say that because I think it's super easy and it's justified to say the rule of law is bullshit, right? Like it's nothing. But all I guess I want to say is that in starting with this ideal is that the ideal can mean something because you can hold on to it and say, what's happening here is not that, right? It's something to aspire to. And so I was going to, but I don't need to, sort of recount just how badly we're doing in prisons in terms of meeting this ideal I was talking about. So not just Justice Arbour's report, but of course, and you all, have been hearing about these multiple examples over the last couple of days. And you've seen, the human rights reports, the public inquiry reports, the coroner's reports, the Senate and Legislative Committee testimony and inquiry testimony that Kim has given and others have given from E. Fry. You've seen the OCI's annual reports and other special reports on the multiple continuing ways corrections is failing to uphold the law, even the law on the books, the law that it holds out, not to mention these bigger principles in which those laws are embedded, principles of human rights and this kind of responsiveness that I'm talking about. So we've heard about and we've seen, and some of us have experienced this illegality, from physical and sexual violence to illegal injections without any consent, to illegal segregation. And then, of course, we've raised this question, when is segregation even legal? Under what kind of twisted understanding of this idea of the rule of law can it be legal to put a person in those kinds of conditions? Let's say it's done under law. So there is a real, there's a real discrepancy, obviously. In I don't want to totally monopolize, but we gotta say as well, right? Beyond these, right? Thank you.
You're doing fine, sister, go with it.
All right. Beyond these, like, specific breaches of rules in individual cases, we can't not pay attention to the bigger systemic inconsistencies with our fundamental legal values that are borne out in the prison system as it exists. So just some stats that Howard Sapers threw out at a conference last year about changes in the last decade in the prison system. Overall offender population has increased, right, by 17.5% in that decade. The Aboriginal offender population has increased by 47.4%. So Aboriginal people now represent 22.8% of the total incarcerated population. The Black offender population has increased by 83% and now represents nearly 10% of the total federally incarcerated population. The Caucasian offender population decreased over this same period by 4%. Women offender population increased by 66.8%. Aboriginal women's population, and many of you know this, but it's mind-boggling, has increased by 112% in the last 10 years. And last stat, because it really is mind-blowing. But in 2012-13, upon admission, 61% of offenders had an identified education upgrading need, defined as less than grade 12. Right, 61% less than grade 12, and 37% had grade 8 or less education. That's in the federal system. So it's important to take seriously. This is like the first question: is the rule of law just bullshit? This goes to systemic inequality being expressed through this system. It seems kind of like it is, right? If we look at this, and I think. The last thing that I want to say, because I actually have a more hopeful vision of ways we can subvert the rule of law, we can use the rule of law, activate the rule of law to do something, to aspire to that ideal, but I'm going to shut up about that. But my last point to cap this off, and I think it might be, for me, one of the deepest questions that we ask of law at this conference, it's back to this question: is the rule of law just bullshit? Because it goes in part to the justified use of war measures on the part of prisoners in response to the wrongs that I've just mentioned. Right? The rule of law is about a pact between legal authorities and those subject to law. And that pact gives you reasons to obey the law. When that pact is broken fundamentally, you don't have those reasons anymore. Right? So I don't deny there are moral constraints on doing harm to others, on doing violence to other prisoners and to prison authorities. Yes, there are moral constraints, but we can argue about what those constraints are in what is effectively a state of war. We can argue about that. They're not the same as the constraints stated in law. I think that's a fairly big deal. So I'm saying it's not just the continued vulnerability of inmates, of prisoners to arbitrary power that's at stake in this claim, right, that the rule of law is just bullshit. I'm saying it goes to the justified use of force and other illegalities on the part of inmates, on the part of prisoners. So that's just a little something to lob.
Back to me.
Back to you.
Back to me, babe.
Thanks.
And just before that, I want to say that those of you who may be interested in prison law next year, we're going to have that as one of the advocacy challenges that we're going to be taking on, is how do we actually mount that as defenses to some of the charges that are being laid against prisoners. So just to, see those of you who are watching on video conference that might be interested next year, just to be aware that that's coming up. And now the question that I'd like you to look to is some of the ways we've spent a lot of time, those of you here on this panel, as well as many of you in the audience, doing things like developing mechanisms, and law students here at the University of Saskatchewan just did a new version that we were hoping to launch here. You'll all get an email when it's ready, and the link to the new Human Rights in Action for provincial prisoners here in Saskatchewan. Law students at Ottawa U and Dalhousie University, and women in and from prison, and our regional advocates across the country worked on this federal one, and you're welcome to look at it. And these were developed because there was a recognition that people needed to be able to quickly access some of the information. So you'll see it set up based on the questions asked by women in prison, predominantly women, although the one that's being developed for Saskatchewan will be used for men as well. And it's basically the questions they ask that they need to know sometimes very quick answers to. Every woman in every federal penitentiary has access to this book. A lot of men get it too, but that's less systematic. And thanks to the work, and Fred's here from Department of Justice, and others from the Department of Justice, and Laura, who facilitated our access. All of the men and women in provincial jails in Saskatchewan will also get this manual. So that's one mechanism. It's not a radical mechanism, although some people see it as radical. What are some of the ways that we could activate or radicalize more without putting at risk prisoners to actually engage with the rule of law and demand that the rule of law be implemented, besides things like being able to put in grievances?
Okay, so what are our options? Is that what you're trying to say?
Yeah.
Well, I didn't know when I went to prison what a grievance was. I didn't know that I had a right to grieve. Well, not to grieve, but like just filled a grievance. And then I learned that it was through people like other inmates that have been around for a long time that teach you that. So I think that it should be more explained by your peers to say to you, like, this is the road you can take. They're not the guards. No one's gonna get their hair in a tizzy and so-and-so's doing this, writing a complaint, or, to help the women or the men just do the things that are necessary to make their time a bit better and to be treated fairly and to have a right to say, like, I have a voice. This is my complaint. Please listen to me impartially and tell me where to go from there. They do tell me where to go, trust me. But I think that, it's really important that maybe like in a jail it would be so hard to have like one person just on your range that will help you, because I know like I call you and then you help me fill it out, but before that I had no idea. So I'm saying I think it's important for the women to know that this is an option available to them, but it's kind of hard because you piss the guards off, right? So you kind of, sorry.
Sorry to interrupt you, but so that's an important point. The law says if you use the only mechanism available to prisoners is the complaint and grievance mechanism within the prison context, within the Corrections and Conditional Release Act federally, and within provincial corrections legislation. They have a slightly different procedure, but that's the mechanism available. Yet, and the only place we ever saw it documented was when we did the human rights complaint in 2001 to 2003 federally. We actually did find documentation of corrections actually saying, if someone uses the grievance procedure, it's indicative of maximum security behavior. So very clear.
That's to say, why buck the system?
That's
You're
right.
trying to
So
get.
even though the law is that you can't experience repercussions, it's illegal, in fact, for you to be punished for using the grievance system. Practically, most prisoners would well, what would you say to me?
Can't fill the grievance, I'm in trouble. There's
Yeah.
a ghost in my room.
Well, you'd say actually other things besides that. I was thinking you'd make, but yes, people would say it's a waste of time and various other expletives usually about that. And the reality is, it's been very difficult. Yet,
the staff has called that?
Hmm?
You know what the staff has called that? Snivel sheets. And that's it.
Yes.
Okay.
So, yes, the staff have called it worse than that as well. And even when we went into the provincial jail here, one of the things one of the unit managers said was, you're going to talk about this, I'm going to have a whole bunch of grievances on my desk. And we often talk to many progressive corrections folks will say they understand that a good litmus test of the health of their institution is if they're getting a good lot of grievances, so that people are using the mechanism available to them.
But sometimes,
to air
when
their
you
concerns.
try, is a 50-50 split. Like some of the girls say, you know what, Lisa, don't rock the boat. You know, like it'll pass, this will be over. And other people be like, you have rights, and you fight for your rights. If you're gonna do your time like that, you're gonna be a wimp. Like do your, you know. So I mean, it's such a 50-50. You know, and you're trying to go like, what should I do? What should I do? And it's very difficult.
Yeah, and Louise Arbour documented that it was some of the grievances of the women that made the most sense of the documentation of the issues at the Prison for Women. And she read out grievances and
Paper trail.
and issues that the women had been raising. And it took a long time to encourage the women to actually file those grievances because they didn't see. And practically, one of the things we often say is, the reality is you may not see much movement, if any. And yes, the pressure, the heat will go up before it goes down. But if you never document it, nothing will change. And this came very clear home to me when I started in this job. And I went to the Prison for Women, and I met women who told me about the fact that it was Gail Horry arriving, a woman serving a life sentence at the Prison for Women in Kingston, that got hot water turned on. And to me, that was indicative of particularly women, but now I would say most prisoners and those with mental health issues in particular, Indigenous prisoners, those who are most marginalized, won't use the mechanism. They don't trust it for good reason. And their view is that they don't have the power or authority to insist on their rights being administered, their rights being recognized or upheld. And some of you
I thought
don't
it's a
know.
good question. You put a grievance, does it go in your file?
No, it doesn't go on your file. Shouldn't go on your file, I should say. Sometimes it does, and you have to get it taken off. And that's what happened with this woman who had uncovered doing a human rights complaint. But it took, for an example, when Gail Horry arrived at the Prison for Women, there was no hot water in the cells. She asked the question. She came in having transition class because of her education. She said, well, why do we have hot water? It looks like they have hot water. And she put in a grievance, and the long and the short of it was, nobody had ever asked. None of the women had ever asked to have hot water in their cells. They just had to turn a tap. They literally had to turn a tap to start hot water. And that was their excuse. It's not a humane response. It's not an empathic response. But it was indicative of the type of work we needed to do. And so I'm interested from your perspective, how do we support and shore up women to be able to exercise their rights in those
But
ways?
you have to take away the fear, right? Like you have to take away and be like, so-and-so will help you fill out this form. And then it goes, like, cause I don't even after all the years I was in, I don't know how it works really, I know that it is an option, but I know that it can make the guards really mad and make your life not even happy, and they don't even know it's in the grievance sheet, but I think it irritates them. And I think that I don't know, Kim, you got me pickled.
I have a story. When I transferred out of Kingston, wound up in RPC, they were denying the women an hour a yard in exchange for the ones who did do a drug and alcohol program to have coffees and donuts as a reward for finishing this program. And they were saying, well, you got to make a choice between all the women isolated within a men's prison onto a specific unit that gets an hour a yard. The prison told them, well, you got to make a choice. You either go to yard or you let these women have their donuts and that. And I thought, let the women have their donuts. And the minute they got out the door and they left, I went up to the window and I says, well, when do we have yard? And they go, you don't get no yard. I says, even under the Geneva Convention, the World Court, it says every prisoner is entitled to an hour of outside yard. I says, who are you to even go against the Geneva Convention? What he told me was, Yvonne, it's not P4W, and you better shut up, because part of the reason why I was transferred out of P4W into RPC was, one, I thought I would be able to attend my uncle's funeral, but then I thought that I would be transferred back because I had to testify at the goon squad, at that whole thing. But when they got me transferred out, they would not let me transfer back to continue with you. When I asked to talk to the IPSO or security over wanting this yard, they sent in the IPSO, who came with a great big male guard who was in transfer because his life was in threat because he was transferred from PA for shooting a Native person. So they said that his life was under threat and that the prison would riot if he stayed there, so they moved him out of there and put him into RPC. Well, when they came to approach me, they took me into a little small glass room across from the glass bubble where the guards were, and then they put a nurse on me because it was a psychiatric center. In Kingston, they wouldn't put a nurse on you. They just put the security and mail on you. When I went into this room, they had those big, ugly radios that weigh about 10, 15 pounds each, and they're trained to use that as a weapon. So they carry it as a weapon. When I went into this room, they had that man there that I knew killed and shot the Native man over here, and that he was here, and he gets to do whatever he wants. Gets to fight, beat up, and he's never held accountable for it. Not under law, not under anything. And then the head of security that was going to give him the okay to do it. And I sat there and I started grinning, I started smiling when everybody else would probably be shitting bricks. But you know why I was sitting there grinning and smiling? Because I turned around and I says, well, if you beat the shit out of me, I hope you leave a lot of evidence so that I can give it to Kim so Kim can come back on your ass. The other one was, even if you kill me, you ain't gonna get away with it because Kim's gonna come and make sure everybody finds out about it. So I remember back to the time when I first met Kim, was walking down a tunnel and she was waddling because she was big, fat, and pregnant with her son, Michael. I thought it was strange, out of all the women in the prison that I seen Kim, and I usually never cracked or talked to anybody, but for some reason, I stopped to talk to her to ask her who she was and that. And then it reverts me back to when I first got arrested. They said, if you need help, call Kim Pate. Or not Kim Pate, E. Fry. Here's the number. So I phoned, and they answered, and I said, hello, I'd like to talk to E. Fry. And they says, she's not here, she died 200 years ago. And I thought, all right, he was pulling a joke on me. So I didn't even have the inkling what E. Fry was. And then when I got to P4W, I met Kim. And it was through Kim that this thing is even happening here today.
Yeah.
There was no outside intervention into prisons whatsoever at all. She blew that door open. Through her position.
We're looking for radical new ideas.
But that was, she was our radical brand new idea. She still is.
You know one thing about Kim that I noticed with Kim after all these years that she is the most.
Okay, all right.
No, wait, one more thing. No. So anyway, Kim has been the most empathetic, understanding, awesome person that we've ever dealt with. She's like a con, but not a con. And she's like, she walks the walk, she talks the talk, but she's been phenomenal to us, and we love you. Okay, sorry.
What I'm saying is, if Kim can do it, everybody can do it. They can learn what it is they need to learn.
Yeah.
Okay, I have one other question. Thank you very much. That was very sweet. I will aspire to live up to it. Okay. One of the things that you raised that I do think is really relevant and just has come up again recently is when you're saying you want to call someone, what happens, and you know, we had an incident that I thought was being referred to earlier in the media panel, but it actually wasn't. There was a woman who self-injured at the Regional Psychiatric Center almost 2 months ago now, and one of the challenges became the amount of pressure that came on her to recant what had caused her to self-injure. And I'm not going to say the details here, but suffice to say, I hope it comes out publicly. But she has now, you know, it's the first time ever, there's a whole bunch of firsts this year. I had, for the first time ever, watched corrections, a correctional supervisor pepper spray a woman in front of me. I never thought I'd see that. That tells, when you talk about states of war, that tells me there's a perception that there's an ability to act with impunity, but also, once we raised that issue, it was clear the staff had no idea what the rules were about when they could use force, in particular pepper spray. So that raised some issues for us about, urging corrections at the very least for people to know the law. The other thing that happened was when this woman self-injured, and she was just across the road here at the hospital, right here on the campus, and we had to argue for her to have right to counsel. And I mentioned earlier this morning about the challenge of getting in to see Ashley. This woman, we had to argue for right to counsel, and they actually had 10 people on a conference call determining whether they would allow me to facilitate a call to a lawyer at the Classic, the community legal clinic here that's operated in conjunction with the law school, for her to access a lawyer. And I said, okay, let me get this clear. You're debating whether you can provide her with access to a lawyer. No. I had to step out of the room because they were concerned I was unduly influencing her to want to speak to a lawyer. Now think about it, those of you who are legally trained here, and even though if you're not, how ludicrous that sounds. Could I have been unduly influencing a woman to want to speak to a lawyer? Maybe. And what would be the problem with this? But that was a national headquarters, regional headquarters, and local conference call to determine whether, in fact, that call should be facilitated. That is a legal reality that I don't think most lawyers ever think about, or law students, or maybe even law professors when they're teaching. That when you talk about right to counsel, you might be actually talking about something much more fundamental than just how do you call a lawyer, but who gets to determine when you can call a lawyer, and who gets to determine who the right lawyer is, and who gets to determine if you're maybe being wrongly encouraged to talk to a lawyer. I mean, I don't think we ever think of some of those things. So when we talk about radical interventions, I think we need to be talking also about how do we put some of those protective measures in place. And you guys have talked a bit about that, and I'm now going to encourage Sheila to take us a bit further down that path.
I think I'll just reiterate some of what you said, and I'll try and be brief because I think we're getting close to the end. I know people probably want to ask one thing or another, but I want to start with something that Deborah Parks, sitting right there, suggested in a neat piece that she and some others wrote in 2008 called Listening to Their Voices. So she was speaking with women and about the various needs that they identified. And I think they go to this question of how do you activate the rule of law inside prisons. So there's 4 of them. One, and that we've heard about this, but I'm just going to formalize them. Better information about existing rights and meaningful delivery of that information. So we've got that. And then can we have some more? Can we have some talks about this? So there's that. Second, accessible and knowledgeable advocates. So there another point that this could be lawyers. It's great if it's lawyers and others too. Third, Aboriginal spiritual and cultural supports. Yay. So let's not forget about the spirit in these dark places. And last, independent oversight and accountability. And access to courts is something that Deborah and Kim have really emphasized, but Deborah, as she was just talking about her last session, also talks about the need for something like a prison inspectorate. We do have the federal correctional investigator. Can we have something like this happening in provinces? And perhaps there are initiatives. Initiatives around judicial remedies, and Justice Arbour had some suggestions around that, and also improvements to legal aid. But I want to add my bit that I wanted to throw in on this is a complementary strategy, and it draws on 2 important legal cases that have come down from the Supreme Court of Canada, one in 2005, and the prison law junkies around here will know this one well, May and Ferndale. And another one, it's like a follow-up to that in a way, a 2014 case called Kayla and Mission Institution. And if people are interested, I can, write down these names and that sort of thing. But both those decisions affirm and they strengthen the ability of inmates to bypass the prison grievance process, to just junk it. It's been roundly condemned as untimely, delayed, as unfair, as it's mired in all kinds of problems. And sure, we should try and rescue it and make it work. I'm not saying we shouldn't, but you can bypass it, and habeas corpus gets you to a provincial superior court fast. Like in BC, it's, I think, a 6-day turnaround. and this is way, way quicker at getting to some independent oversight than you're going to get wading through the internal grievance process than trying to get judicial review in the federal court. So that's kind of neat. And Deborah has done a lot of work on this as well. Deborah Parks, she wrote a paper on using habeas corpus. Sort of, let's make this thing work. In my province in Nova Scotia, it's being done without advocates. People are handwriting, as Deborah was just talking to me about, handwriting their habeas corpus applications. It's meant to be easy and quick, and they're sending them like in bulk to these judges. And we just got a great decision. Richards, I think, is a pretty good decision out of Nova Scotia where a guy won. So what's habeas corpus real quick? That's a type of legal challenge where what's alleged is an illegal restriction of liberty. So beyond being confined to prison, it's an illegal restriction of liberty. So this means it could be a decision about segregation. So your liberty has been constrained within prison. It could be a transfer to a higher security level, right? That's a restriction of liberty. I think your point, Lisa, you're making about restraints. I haven't seen much work on using restraints in habeas corpus. I don't know. I'm not the expert here like Deborah. But let's do that. And bring those complaints in bulk to the prisons. How are they decided? Well, the prisoner has to show that there was a constraint on liberty. That's your job. It's done. And then the onus is on the institution to show that it was lawful. And how can you allege it was unlawful? Number one, it was procedurally unfair. That's how the guy in Nova Scotia won. He didn't get disclosure of the case against him. This is a basic principle of law, but that's the one that you're most likely to win on in the courts, to be honest. But there's something new, and this is my last point. This is what I love. I love this stuff, this development of law. This shows you that I'm actually sort of romantic about the rule of law at heart, because there's this one thing. It comes out of a case called Dore against Supreme Court from 2011, and it goes to what you expect of the use of discretion in law. So when you're making a decision about putting a person in segregation, when you're making a decision about transfer to a different security, that's using discretion. It's using facts and laws in these sort of manipulative, it's called exercising discretion. You're making a judgment. So where a discretionary decision is an issue, and where that decision, number two, engages what we call charter or constitutional values. Liberty is definitely a charter or constitutional value, but so are other things, right? Like Aboriginal rights. Those are constitutional values, right? If you're not getting access to spiritual, right, services, whatever, that's engaging charter values. So where that happens, where you have a discretionary decision engaging charter values, then that decision has to be reasonable in law. And what does that mean? Okay, I'll give you another word. And this is what the little education project would be like, sitting around the circle saying, how do you make your habeas corpus application? Well, the decision has to be reasonable. And what does that mean? It has to be proportionate. Well, what does that mean? Like proportionate, that's just playing a game about balancing like liberty versus security. It's always like that. So it's just a shot in the dark. But the courts have tried to give a little more structure to this idea of proportionality. And so they've said, for instance, if liberty interests are sacrificed absent any evidence or on the basis of unreliable or irrelevant evidence or evidence that can't support the conclusion, then it's unreasonable. It's unlawful. So this is just, it's a little wedge, just a little opportunity to start bringing in this discourse of charter constitutional values right at what I would call the rock face of prison discipline, of prison grievance, in the courts, but also right to the face of the person exercising discretion. It has to become part of the language. And honestly, my very last thing is back to a story that Yvonne told me yesterday, and I don't know if she has time to tell it, because I just loved this story about the snares, setting snares. Right? So she told me a story about making a joke with a prison official at the RPC. She was going to set some snares for rabbits in the prison grounds. She was going to do some hunting. And she justified that. It was kind of like, and she got in some trouble for saying, what, you're going to hunt in the prison, right? But she justified that by bringing in what I would call a constitutional value. It's what? How did you justify it? Go on, please. Please. You're the storyteller. I'm not a good storyteller. So if I do it, I'll totally...
When I went up for my 15-year review, they go through your whole prior incarceration with a minute comb. in the end, they try to figure out how many times you've been charged and all this and that, and you're a really bad guy, you know, like, anyways. They went and they tried to figure out how many charges that I had and calculated up over the 20 years, which only in 20 years, I only wound up with like 2 charges. But there was 2 other charges they were trying to bring forward too that the court said themselves was, we're not gonna accept that, was they were trying to charge me for asking or requesting hunting permission inside a federal prison. They were told me I was not allowed to hunt inside of a federal prison. And what I told them was, I was actually putting in a garden and it was just a conversation. And this guy goes by making lightly, she goes, you're gonna have some heavy competition with the rabbits around here, they're gonna eat your lettuce. And I says, well, bottom line, I says, one of us has gotta go, I says, and national parole ain't letting me go, so I guess that rabbit's gotta go. And she goes, well, how do you profess to do that? I says, well, I says, there's always I have a right to eat my traditional food. I want some, you know, rabbit soup. Oh, what do you want rabbit soup for? He says, you get your canteen. You get your food out of the kitchen. And I says, well, I have a right to eat my traditional food, eh? And as long as she was going, I was meeting her. And I thought I was holding my own pretty good here, eh? Because back home it's called terrorizing. You kind of up. And I didn't realize how serious she was taking it, you know. As she turns around, she goes, well, how are you going to get them? You can't have firearms. I says, well, I just get snares. She goes, oh, no, you can't get snares because the guards will fall into it and they'll hurt themselves. I says, natch. I says, all you got to do is get small little wire big enough to catch their little heads and you got them. I says, and she goes, ah! And she goes, well, you can't hunt in prison. And I says, wrong again. I says, this is land set aside. It's Crown land, and I have treaty status. So I'm telling you, I have complete authority to hunt on this land. And she goes, I want to find out about that, she says. And I got written up for requesting a hunting license inside of a federal prison.
See why this job is so fun?
Can you tell the duck story?
No. Oh, yes, and then there's Lisa's stories. So that was fabulous. Thank you, all of you. And just so you know, those of you who work in and around and know what the evidence that is relied upon is often third party, and so I think there's an easy way to challenge the reliability or lack thereof of some of that evidence. So I'm really excited about those options, and you've agreed to share your paper too, right, Sheila? So we can use, yes? Yeah, yeah. Oh, no, hang on, there's probably some questions, so if anybody has questions. Yes.
Going on, first time that I joined Elizabeth Fry, went to jail with Denise, or with Mariana and Denise. We used to have bingo on Wednesday night, so that's how they start you to get in. Oh, you do bingo or whatever. And that's when the Walkmans were big. So I never really been in an institution before, so I was a little apprehensive and, you know, I got in there, had fun with the girls. We had bingo prizes, and one of the bingo prizes were batteries for their Walkman, okay? So the next time I go, I guess some fights broke out because they wanted some batteries. So all of a sudden, we weren't allowed to have batteries for bingo prizes because they were a danger. But they still had the batteries. So in my head, I'm going, okay, so new batteries are weapons, old batteries are good. Because, oh, well, they could put them in their sock. And I was like, old batteries, new batteries, it doesn't matter. Like, they didn't ban batteries. They just, any batteries, just the new ones that we were bringing. So when you're talking about law and things, and of course, we would have our Christmas party for our girls, and we, you know, scrounge together, because we're just a little place. Scrounge together and get some pizza or whatever. What did they decide to do? Go through the rooms. So everybody was in lockdown. So here we are with pizza and everything waiting, and just little mind games that they even played with us.
Yeah.
And then, you go back in next year, they wouldn't even talk to you due to the time of day.
Well,
But when we had pizza, they
come,
opened the
yeah.
door for us.
You know, like, I think it's so funny, like, for the lack of understanding that they have and the little things. Like, I know when we moved to Edmonton Institution for Women when it first opened, there's an enhanced unit, you know, there's, how many of us? 8 of us here, Kim, in the enhanced unit. And they had said, you know, we're gonna give you guys jobs. We're gonna let you guys work in maintenance and blah blah blah. So like, yeah, okay. And then the cutters, we kept thinking like, what do we get to cut ourselves, right? Like, and so we bring these big honking razors from maintenance, and we bring it to her. And our metal detector in the enhanced unit had no batteries, and it had no thing. So you're like packing everything through there. And the guards were like, you know, scared about things like stupid things like that, and we had everything else. It's ridiculous. And if you want a weapon, you'll find a weapon if it's a toothbrush or a.
Well, that was my thing.
Yeah.
Like I said, the old batteries were still using the Walkman
Yeah.
that month.
I think that's because they see any outside people lending support
Yeah.
Absolutely.
Yeah.
is they're gonna make life impossible or miserable
Yeah.
for you, that you're gonna die out, you're gonna go away, you're
Burn
gonna
away.
decide not to come back. It's like the media using that piss poor excuse, well, they won't let us in. Well, all you gotta do is write the inmate, ask them to send a visiting form. They get cleared on the visiting form, they get clearance on their phone numbers, and they got direct contact with each other. And there is no way that can be cut off.
Doesn't work as well anymore, Yvonne.
No?
No, if you get, apparently they tell you now, if you end up on a visitor's form, you're not allowed to see anybody else.
Oh, really?
Media, yeah, so.
Yeah.
They get us
Yeah.
that way.
Yeah, no, there is a challenge.
And they take us off the pins if they try to.
Yeah.
It's
Yeah.
pain.
I'm just-
But when I was a president, they didn't have this new pin system.
Yeah,
But
I
they
know.
should
Crazy.
have a legal right to have access to media.
I don't disagree, but that is a challenge that we're having right now. And I know Amanda and Leanne had questions, and then we should probably let you guys have a break so you can go to the next session. They'll be back for the lifer session, so if anybody wants to come back.
I was just going to say, I like your term, Sheila, about war. Even, I work at Classic, which is, I guess, the place you were unduly influencing the woman to call. And just this week, it feels like we're part of the war that's going on. Just this week, we've had a student be told by RPC that students are no longer able to talk to people at RPC because they don't consider them lawyers because they're students.
Yeah.
Where for 6 years, we've been representing people at RPC. We just ran the stats, it's about 32 visits. But this year, this week, just the beginning of this week, they've decided that students aren't allowed to talk to the residents.
How are you appealing that? Like, how are you gonna fix that?
Oh, we're fixing it. And you'll like this, the student hung up the phone and, pardon my expletive, said, oh, for fuck's sakes, I can't wait till the day I'm a lawyer, I'm going in and giving every one of them my card.
Yay! That's great.
It's
So,
just, you
yeah,
gotta
it's
keep
really
plugging.
frustrating.
People has got.
Yeah, you gotta stand up and
Can't
just
wait to
fight.
be drafted into correctional law. Correctional law is one of the newer laws, I guess, in all of Canada. And yeah, go and become a lawyer, go and become an advocate. Fight for the ones that got no voice. During the Arbor inquiry, there was a quote. They said, you can always tell the condition of a government on the treatment of how they treat their prisoners. So if you figure that, and people's got to realize what they do to one, eventually they're going to do to another, and that's why people are waking up to the situations and the dynamics of the world around them, because there's no place to run anymore.
C51 is teaching people that lesson, yeah. Leanne, you had a question?
Yes, it's around proportionality. I'm really excited. So we keep running up against the fact that women being sent administratively for investigation around a reliable source, and it's gotten to the point where they've been reclassed to max, and we're seeing it a quite frequent trend. So my question one is, you said it was a court decision that you read to us about the action, if I remember we did that. And two, am I hearing you correctly, would that be, because it was a reliable informant, would that then not fit the criteria for being proportionate for consent for investigation?
The second question, I'm just going to have to put aside in pleading sort of ignorance. We could talk about how you might argue it, but I don't know. Just like if it's just necessarily going to be disproportionate. That's the thing about proportionality, is it's not necessarily a guarantee. It's not like sometimes it's such an obvious case, you're done, and that's usually anyway. So the case that you're looking at to get the framework. So what I can give you is the framework, and then you've got to fill it in. But the framework gives you some pretty I think, potentially strong tools. It's from the Kayla case, so K-H-E-L-A. That's Kayla, K-H-E-L-A, Kayla, and Mission Institution. So it grew up out of BC, but it's a Supreme Court of Canada case from 2014, and that's all you need to find it, is Kayla, Supreme Court of Canada, 2014. Yeah.
Right. Well, thank you very much for another great panel. Have your break and be back in 2 minutes. If you're coming back.